or within the zone of reasonableness. Now, we have been told about many things that the ECK tried to do right. The resource transmission system, the electronic voter identification device, the BVR register. Then I looked at some jurisprudence from India, and I found a very interesting case. And this is the case of Chris Tapper versus Chief Election Commissioner and others. And this is to be found in, which volume is this? Yes, it's actually to be found in the supplementary list of authorities, and it's on page 28. In this case, the court said, the Supreme Court of India said that time and time again, we have held that the actions or directions in conduct of elections in a free and fair manner shall be left to the Election Commission, and courts shall not ordinarily interfere in an order passed by the Election Commission unless it is brought to the notice of the courts that the Election Commission has exercised the power which it was not vested with or acted in an arbitrary manner. Now, again, if you look at the Constitution of India, and particularly Article 24, you will find some provision or some articulation that is similar to ours, in the sense that it says that the Electoral Commission has superintendence, direction, and control, as well as the conduct of elections. Now, our Article 88 says that our Electoral Commission is responsible for conducting or supervising referenda and elections to any elective body or office established under the Constitution, and any other elections as prescribed by an act of Parliament. What was interesting about the Indian decision is that they found that there is what you call the plenary power that resides in the Election Commission, which means that not everything will be written in the law. The regulations, the Elections Act, there will be bits that will be omitted. And for those, it is for the Election Commission to make the decision to determine how best to run the election. And so when the BVR, when the computers crashed and some data was lost, was the Election Commission to sit back, twiddle its fingers and say, oh, the BVR has crashed, we can only capture, only those who are on this BVR register can vote. And then the resource transmission system stops after 14,000 polling stations have sent in their reports. So do they say now, what do? We sit back, we cannot now continue with the manual system, which in any event is statutory and it is provided for. Is that what the Election Commission was to do? Should we hang them? Because they exercised this plenary power that resides in them in order to give us a free and fair election. That cannot be the position. Now, another issue that we must again urge Your Honors to bear in mind are the general principles in determination of election petitions. Again, in my little time, I find it difficult to keep on referring to these volumes, but I know Your Lordships will look at them. But the position really, looking at all the decisions that we have looked at across the Commonwealth in the region, it is the duty of the courts to protect and preserve the integrity of all constitutional commissions. And in fact, when you touch them, then you have to exercise a lot more than ordinary care. And whatever they do, we will, if the first premise say, this was done in a bona fide manner. We will not run to crucify our nascent institutions, because if we crucify the Independent Electoral Commission today, tomorrow it will be the Salaries and the Remuneration Commission. We will have a lot to say about the CIC, and who knows, Your Honors, maybe some will also have something to say about the judiciary. So we must nurture our nascent institutions. Here is the IEBC, which has been barely in existence for 18 months, has carried out in 18 months what would ordinarily be carried out in a full election cycle of 5 years, and they have managed to pull it off. And we tell them, no, you are shabby, and we don't trust you. That is not the way to treat a constitutional commission, because then what this ends up being is what I can only call, you know, it is actually populist attack on a constitutional institution. And what that means is that the people of Kenya very soon begin to lose hope and trust in institutions that we have painstakingly sought to build. And again, you will see the process in which we actually elected, or rather in which the commissioners were appointed. A very competitive process. The principals had a say in it. The National Assembly had a say in it. And we still say we are in 2007. It cannot be, unless, of course, we are being very sparing with the truth. Now, the other case was mentioned to you by my landed friends, the Lary for Democracy and Progress, and basically what it says, it has been the policy of the law and even the English courts not to disturb an election when it is clear that the persons who voted were entitled to vote, that no one entitled to vote has been debarred from voting, and that all requirements of the Electoral Act have been substantially complied with. The other decision I would wish to refer to is the Election Commission of India through Secretary versus Ashok Kumar and others. And in this case, the Supreme Court said that a conscientious approach with overriding consideration for the welfare or the constituency and strengthening of democracy is called for, neither turning a blind eye to the controversies which have arisen, nor assuming a role of over-enthusiastic activists would do. These two extremes are to be avoided. Again, because I don't have enough time, I can only touch on a few other areas. Non-compliance with the law and whether the process was therefore materially affected. Again, Section 83 of the Elections Act says that if it appears that the election was conducted in accordance with the principles laid down in the Constitution, then, and the result is not affected, then we shall let it rest. And we have several decisions again that address that. Joho versus Ngare, again you find them in this list. And there is also Morgan and Simpson, which was referred to by my learned friend. Then I found a very interesting case also from India, Kalyan Kumar Gogoi, which says that even if a polling station, for example, is shifted, that would not be considered to be an issue that has materially affected the elections or the outcome. The other decision that is interesting is Paukai Haukip versus Rishang, again from the Supreme Court of India, which says that the court actually refused to accept the statement of a headman that the whole village would have voted in favor of a particular candidate to the exclusion of others. They said that it was not possible to determine what voters' choices were. The other authority that would be important is a Botswana case of Pilane versus Molomo, which says that what should be emphasized is not that we intend to always hold a new election when a petition is filed, but is to find out how, despite the irregularities, a new election need not be held. And then I would, of course, refer to an important aspect, the sample areas that were picked by the petitioners. And just to refer us to the Kiza Besigye case, and again, Your Honors, I hope that you are not going to write a decision this long. This is the Kiza Besigye decision. But what the Supreme Court said, Your Honors, is that the sampling strategy ought to have been the simple random method in which all polling stations would have an equal chance. What then meant is that the petitioners in that case are determined which areas they would sample. It was not a researcher, an analyst who actually was asked to do this job. So again, you have to look at those units with a lot of caution because they were selectively picked. I found a very interesting case because again, my learned friend, senior, Mr. Oraro, referred to a decision that tells you that if you find that somebody extra was registered as a voter, then you are now to totally disregard that. According to him, if after the 18th of February, the voters' roll was opened, then it means that the whole election is to be trashed because, again, of that breach. Now, what this authority from India, Indrajit, Barua, and others versus Election Commission of India says is that the validity of election could not be called in question on the ground that electoral rolls were defective, as the finality of the electoral rolls could not be assailed in an election petition. And they looked at the Indian equivalent of the Act, Representation of People Act, 1951, and said that that was not a listed ground for declaring an elected, a returned candidate as invalidly elected. So merely because you have a problem with the roll, that is not a ground for trashing the outcome. Then I'm told I should wind up. And I just need to refer to one thing and basically ask of you judges that you would be consequentialists, because again, you can see the consequences that we are being put into as a country, the fact that we may not even be able to hold an election if you were to say we go for a runoff. There were also two decisions that I would have wished to refer to, and this refers to the case that my learned friend, Mr. Orado, brought up, the Nigerian case, basically saying that you shift the burden of proof. But now what I found when I read that decision, Your Honor, is that actually it is a very special statute that says that if you are the candidate who has won in an election and your petition is challenged and you're found to have been, or the charges that you committed election offenses, then it has a very special procedure for dealing with that kind of case. But my colleague, Mr. Mohamed Nyaoga, will take you through the burden of proof to show that we have not changed our standards with regard to the burden of proof. Again, I will have to leave, though I had a lot more to say. Please do look at all these volumes, and I wish you well. Yeah.
Senior Counsel Kambuni, I noticed you are reading from, some typed materials.
Yes.
And I guess that is actually probably the abridgment of the big volumes.
It is.
Then you need to give us that.
Yes, I will do that.
Because although Judge Ojwang tried to slow you down,
yes,
you actually increased your speed. I couldn't catch up with your...
I was thinking about the 15 minutes, but nonetheless, we have actually, I think we should have filed by now our submissions, and all of these, the summaries
If we can get the abridged version,
we'll
that
do
would be very good.
Most obliged.
Thank you very much.
Yes.
Mr. Rebello.
May it please the Supreme Court. There have been, both parties or all parties have relied very heavily upon decisions of the Supreme Court of India. And one significant point arises from this, that the Constitution of India places two state organs on an equal par. These are the Supreme Court of India and the Independent Electoral Commission. They both fall under the immediate purview of the President of India and are not permitted for political interference. Your Honors, we have set out to deconstruct the petition piece by piece, paragraph by paragraph, to demonstrate to you that it is based upon a false premise, and to establish that the allegation of conspiracy is not true. This is the fundamental issue, the grave insult and attack which has been launched against the IEBC. This petition has set out to undermine this very important institution of the Constitution. And it is reckless, misguided, and without regard for the truth. I would ask you to consider what the IEBC has achieved in the short period of under 2 years. It has set up the legal framework for the holding of elections under the regulations which have been approved by Parliament. It has set up a countrywide network of constituencies, polling stations, and it has established its presence throughout the country. It has held elections not only for the president of the country, but for 6 other positions in government. It achieved all of this in a very short period of time. In doing so, it has not been criticized by the vast majority of the public of Kenya. The people of Kenya have accepted these results. And more particularly, we have always talked about the people. But let us spare a thought for those who stood for all the other positions. Insofar as the president is concerned, we had 8 candidates. None of the other 8 candidates has even filed a petition, let alone condemned the IEBC. In this regard, the IEBC has undertaken a monumental task, and it has set us on the road to yet another milestone in the implementation of the new constitution. Today or yesterday, the new governors of the counties were sworn in. The new Senate has been sworn in. The new parliament is being sworn in. So the area of complaint that is being reserved is only to the presidential campaign. Now, if you look at it, millions of Kenyans turned out to register as voters. Millions of Kenyans turned out to vote. Notwithstanding the long queues, our people, as always, were good-humored. There were no riots because there was a long queue. They turned out everywhere, throughout the country, notwithstanding the attempt of some people to disrupt the elections. There was no intimidation. Anyone who wanted to stand for elections was allowed to do so freely. All of these events establish that the elections were free and fair. Because the standard by which you judge whether an election is free and fair is by looking to the participation of the people, the participation of the candidates, the participation of the ordinary people in going to vote. Significant issue here, or point to note, is that the same register was used for all the candidates, no matter whether they were for county elections or for the president. Your Honors, it was an act of wisdom, experience, and wise counsel which led the Parliament in November 2012 to retain the paper trail as the principal system of the electoral process. Parliament was not carried away by the enthusiasm for technology and retained the paper trail, which improved the checks and balances. This is apparent from the regulations. The regulations were approved by Parliament, and there was wide consultation with every stakeholder before they were put to Parliament. They were discussed publicly and emerged as a legal document. If I may draw your attention to Regulation 60, Regulation 60 states, where the Commission intends to conduct an election by electronic means, it shall not later than 3 months before such election publish in the Gazette and publish through electronic and print media of national circulation and other easily accessible medium guidelines that shall apply in such voting. Now, this is a fundamental regulation, and it applies not only to an electronic election, which we did not set to undertake. The election was not electronic, the voting was not electronic. And it must apply to all the other equipment which was used, the EVDs, the RTS. There are no guidelines. This is not an easy matter when you look to what needs to be achieved. But the important point here is that Parliament retained the polling system of the ballot. The ballot has got to be taken out of boxes. Each ballot has got to be shown to the people who are attending the counting. They've got to be put into piles and then finally counted. So the paper trail is created, and Form 34 is generated as a result of this activity. Now, Parliament decided to retain that system. And this diversion, with all the talk about electronics, is a mere diversion. It is not law, it is not part of the Constitution. There was an issue about tallying. It has been alleged and a complaint made that the petitioners' agents were excluded from the tallying. The chairman of the Electoral Commission has stated as paragraph 45, page 10 of his affidavit, having explained exactly what happened. Unfortunately, sometime in the evening, the political party agents inside the tallying room became rowdy, precipitated altercations with the commission staff undertaking the tallies, and in some instances threatened to assault the commission staff. This has not been denied. We've had a repetition here in the making of 2007 and of what happened at KICC. It was the wise decision of the Commission to take matters into its own hands and to carry out verification through a system which it established and which is transparent, accurate, and verifiable. My learned friend has tried to shift the burden of proof to the IEBC. The IEBC has cooperated. There was no duty upon it to produce the evidence which it has done. But in making the allegations which the petition has made, it has taken upon itself the burden to prove the allegations of a criminal nature. That burden never shifts to anyone. Finally, Your Honors, I would like to bring to your attention the report of ELOG, which is enclosed at page 56 of the chairman's affidavit. This is an organization, an NGO set up by Kenyans for Kenyans. They have monitored elections in various parts of Africa. They have set out exactly how these elections were conducted. And they have confirmed that the elections were carried out according to law, that the results are verifiable, that they were within their expectations because of the various tallies they themselves were doing, and that the election was credible. How do you judge whether or not an election is transparent? How do you judge whether or not an election is credible? The only way to do this is through reports such as this. This is a Kenyan report by an independent organization of churches and NGOs which belong to Kenyans. Your Honors, those are basically the points I wish to make. If there is any other issue which you would like me to deal with, that's all I have to state.
My Lords, very, very briefly, it is abundantly clear from the submissions of my colleagues. It's also clear from the submission of counsel for the petitioners that the selection that is called a random selection of electoral areas presented by the petitioner was selected mainly focused away from the strongholds of the petitioner. You can draw your own conclusions, my lords. Malanet Senior here submitted that the register relied on for the elections of the president, the process that was initiated and executed was the same register and process for senators, governors, MPs, etc., etc. And my lords, you notice that our learned friends acting for the petitioner, Honorable Orengo and Honorable Wako, are not here. They have resumed their tour of duty. Happily. I think they are going to be sworn in, my lord, today. I wish now to deal with the issue of burden of proof. There are two issues to address here, my lords. Firstly, the burden and standard of proof that the petitioner ought to discharge. But also, I will address another issue, the considerations that the court ought to keep in mind in granting the reliefs that have been sought. Let me go straight away to the burden and the standard. My lord, I did submit in the morning that election petitions are a special category of cases for which a special burden and standard of proof is required. In our band of authorities, there's authority number 41, and this is the case of Bernard Shinali Masaka versus Boni Halwale, authority number 41. I don't wish to read it, but I'll just go straight to the area that I wish to rely on. The burden of proving any allegations made in a petition lies with the petitioner. And then they go to say this: I'm certain that the standard of proof, save in matters where electoral offenses are alleged, cannot be generally beyond reasonable doubt. But because of the quasi-criminal nature of some election petitions, like in this particular one, it is almost certainly on a higher degree than merely on a balance of probabilities. I go straight to the serial number 42 in our bundle. This is William Kabogo versus George Thuo. I go straight to the part that I wish to rely on. On our part, the proof should be such a high standard as to be above quite above the balance of probabilities in civil litigation. Authority number 13. You can see the preponderates of authorities in this area. That is Joho versus Nyange. I agree with counsel for the second respondent that the petitioner, being the one seeking to nullify an election, he has the burden of proof. As you retire, my lords, the question you're going to ask yourselves, from the bits and pieces that you've been given by the petitioner, from the unsupported conclusions of corruption, of stealing, even of robbery, as mentioned by Kate here yesterday, conspiracy, have you been given any evidence to support those allegations? The answer is a resounding no. Lord, on the same decision of Joho versus Nyange, this is what they had to say. Like in fraud cases, I would say that the standard of proof required in election petitions is higher than on a balance of probabilities. And where allegations of election offenses having been committed, as the election court held in the case of Wafula, a very high degree of proof is required, very high. My lords, can you describe the proof that has been proffered by the petitioner as very high? Not at all. I submit, my lords, that not only is the burden to prove the electoral irregularities on the petitioner, but that the petitioner has to prove them to a high standard beyond a balance of probabilities. I submit that the petitioners have failed to do so. What about the reliefs and declarations and remedies sought? My lords, we are dealing with an election petition of a very special category. As I've demonstrated, that requires a higher standard of proof. I submit that in issuing any reliefs or orders, you require a very high degree of circumspection. I submit, my lords, that election petitions are premised on the exercise of a people's democratic right, the result of which ought not to be lightly interfered with. As you see from the various authorities that have been placed before you, the general rule all over the world and attitude of the courts is to let the elections stand. And that is what we're urging the court to do. Authority number 28, Borders versus King. And with your permission, I wish to read this because this is very important. It hammers my point. Election contests are governed by several general principles. Chief among them is the principle that the judiciary should exercise restraint in interfering with the elective process, which is reserved to the people in the Constitution. Unless an election is clearly invalid, this one cannot be described as such, when the people have spoken, their verdict should not be disturbed by the courts. In adhering to the principle of judicial restraint, the court should follow the rule that an informality or irregularity in an election which did not affect the result is not sufficient to invalidate the election in question. My Lord, all the material that has been placed before you do not support the conclusion that the irregularities complained of would have affected the result of the election. I'm going to sit down very shortly, but let me go to one more authority, number 45. Yes, and that's the last one. This is the Republican Party of Namibia versus the Electoral Commission. Let me read this because it's very important. When, however, the election sought to be set aside, the interest is as much that of the constituency as that of the parties to the election. If an election is set aside, the whole electorate is affected, business is dislocated, expenses are incurred by the electors going to the poll, the business of hotels and public houses is interfered with, and generally speaking, a large number of people are greatly inconvenienced. It has been therefore the policy of the law not to disturb an election when it's clear that the persons who voted were entitled to vote, as you have demonstrated. Secondly, that no one entitled to vote has been debarred from voting, as we did. And that all the requirements of the Electoral Act have been substantially met. Before I sit down, public policy is best served by allowing the election to stand and trusting to a strict enforcement of criminal laws for greater security against like irregularities and wrongs in the future. In conclusion, my lords, I submit that the burden of proof has not been discharged by the petitioners, that will require you to exercise your hand in disturbing this election. Much obliged, my lords. I think Wambua wants to say something, my lord, for a minute. No? Much obliged.
Sorry, my lords, I was assigned.
We must follow the order that has guided the court. Are you asking the court to grant you audience?
Yes, my lord.
Were you listed?
We have 4 minutes that are remaining. I just thought there's 1 or 2 things which fell out.
Yeah.
And that will take a minute.
No. Those 4 minutes can be recovered. But were you listed?
No, he wasn't.
So I'm just saying that it's good we follow the rules as agreed.
I am at your lordship's guidance.
Okay.
Perhaps with your lordship's leave.
They have actually 1 hour and 4 minutes. And I thought they were going to donate that time to the court, because we need to write the judgment.
Yes.
You still have an hour.
That hour is going to be taken up by our learned friend, Mr. Abdullahi, together with Mr. Karori. So I just have those 4 minutes. My lords, I just want, sorry, the name is Wambua Kilonzo. Wambua Kilonzo. I just wanted to make a small comment on the video evidence that was adduced here by my learned friend and sister, Kathy Kilonzo. My lords, the question that your lordships must have at the back of your minds when considering that evidence is, does it have any probative value? In our submissions, that evidence has no probative value. My lords, I start on the premise that pictures speak 1,000 words. A moving picture speaks 1,000,000 words, if one were to say so. In those circumstances, therefore, judicial restraint is usually placed on the use of such images for admissibility purposes. That evidence requires that there must be a certificate of the maker of such evidence. And secondly, and most importantly, my lords, there was a narrative that was given by my learned friend regarding that particular video evidence. You remember her saying, you see, the returning officer is reading from a telephone, the people next to him have a laptop. My lords, in our submission, that narrative is not admissible in evidence, at least not if it is being given from the bar. In my submission, therefore, my lords, that video evidence did not prove anything. Apart from the emotive value that it may have had at the time, it has little, if not cosmetic, evidential value, and I pray, my lords, that you ignore it. In any event, even if it had any value, presidential tallies are supposed to be done at the National Center. Any other tally must be ignored. And that is why the commission was given power to ensure that the tallying is done, to ensure that the Form 36s do comply with the contents on the Form 34. To that extent, therefore, I pray, my lords, that you ignore that video evidence for all that it's worth. Finally, my lords, on the issue of technology, which my learned friends have talked about for long, today, my lords, we saw your sound system fail. That is your preferred mode of capturing the records of this court. But when it failed, my lords, and due to the time constraints, the written record of your proceedings would have sufficed to be a record of this court. And to which extent, therefore, my lords, everybody will remember in this court when Mr. James Ochieng Oduol was speaking and his speech went off, everybody remembers that he was talking about IBC, TNA, and KENCOL. Everybody remembers it, whether or not the sound system worked. So that, my lord, even if the BVR system failed, the EVD system failed, as long as the commission went back that which it was mandated by parliament to do, that result should stand, and that result is verifiable. To that extent, therefore, my lords, I think my learned friends and I have said enough to show that this petition must fail. Thank you, my lords. I think it's your turn.
Thank you, my Lord, the Chief Justice and Judges of the Supreme Court. I think as my learned friend said, my Lord, I'm honored and privileged to appear before a full bench of this court for the first time in such an important case. Before I start my submission, my Lord, I would like to address a number of issues raised by my learned friend, George Oraro. Then I will go to my submissions. There are about 6 or 7 matters. And the first one, I think, which has been repeated by a number of my learned friends, is to say that this petition is of momentous importance in this country. My Lord, in essence, in one sense it is of momentous political significance, in the sense that this court will decide whether the third respondent will be sworn in or whether we will have a run. But in terms of legal issues, I think most of you will be disappointed at the end of the day, because really, there is not much law in disputes of this kind of nature. Wenjiku, as have been said, this is a case that does not really concern Wenjiku because there are not fundamental issues of law. As the former president likes to say, there will be no more ugali on the plate of Wenjiku once you decide this case. It's not an important case that has ramification for the average Kenyan. The second point...
You want to treat that as an authority?
Yes, yes, yes. Yes, my Lord, yeah, actually I'm quoting from the judgment of the US Supreme Court on Al Gore versus George Bush, and I will show you where they say that presidential elections are momentous politically, but legally insignificant, because basically you are resolving a dispute between 2 individuals who will go to State House, that's all. So it's a really, from a legal point of view, it's a very mundane point of law, but enormous political ramification. My Lord, the second point my learned friend raised was when he said 86% voter turnout, and he says it's only in communist countries that you find this. I mean, I found it a little bit insensitive when many Kenyans, up to 86%, turn up to say that it's only in communist countries where such voter turnout. And the implication is that when there is a voter turnout of that magnitude, there is always rigging. But I think, to be fair, I mean, many Kenyans made sacrifice to vote in this. I think my learned friend will know that many fishermen in Lake Victoria could not go to fish that night before. They were banned to fish. They were told they must vote first. There were many Kenyans who could not drink their favorite beer because the bars were closed. So I think it was a civic duty for many Kenyans, and many sacrifices they made for them to achieve that 86%. But I will excuse my learned friend for that. It is an instance of the elites speaking down to the common man. Yes. My Lord, I think I will come to the issue of the burden of proof. Many people have talked about the burden of proof, but I think the standard is not really what my learned friend said. The standard for a presidential candidate is not beyond reasonable doubt, and I will show you why. It's only beyond reasonable doubt, for example, when there's a member of parliament, or there's a council, or a governor, because those are representative of the people. A president is not a representative of the people. He is given a mandate to rule and reign. So the standard of proof is that this court must be 100% sure that you will not overturn the mandate of the electorate as a college, because this is one decision, this is one seat that 12 million Kenyans have voted. It's not, for example, like the case of Langata constituency. My Lord, the other issue I would like to talk about was the issue of the special register, because my learned friend again was full of contradiction. At one time he said he is not aware of the special register, but there is one very insensitive statement he made, and I think my Lord Justice Ojwang mentioned it twice. He said this special register is most common in Kiambu, which connotation was that it was in a Kikuyu constituency. Then he said Meru, then he said Rift Valley. In other words, he is identifying 3 ethnic groups to show that the rigging or that special register was peculiar to those stations, my Lord. Nothing could be further from the truth, my Lord, as it has been shown before this court. The other issue, my Lord, is commission of criminal offenses. It's my humble submission that you being a court of first instance, unlike, for example, a court trying an election petition in the High Court that calls witnesses, you cannot find any commission of criminal offenses, because a criminal offense can only be found when you call witnesses, they are cross-examined, and you do it on a balance beyond reasonable doubt. You cannot find the commission of a criminal offense through affidavit evidence. So all the cases my learned friends gave you did not contextualize that, because those are cases that have come through the various levels of trial. My Lord, my learned friend also talked about the BVR procurement. I will address that substantively to show you that this court has no jurisdiction to look into issue of procurement. But I agree with my learned friend when he said this is an issue where there was corruption. Those were his words. He said the price jumped from 3 billion to I think about 9 billion. What he did not tell you, and what he should have shared with this court, is that it is the petitioner's office that was in charge of that process. And probably the petitioner owes an explanation on how that 6 billion extra was paid by the taxpayer. My Lord, let me now go to my submissions. My Lord, again, I think this is your inaugural case, to be fair, in terms of how momentous it is. And I'm sure you will give an inaugural judgment. But my Lord, one of the important things to note about this case is the kind of complaints raised. I call it, it does not raise a third world issue complaints about election. What are third world elections known for? They are known for violence. That's why they said, the foreign media was very disappointed. There was no violence, there was no voter intimidation, there was no bribery, there was no mass disfranchisement. Those are issues that were not raised. My Lord, I would really appreciate if you could look at my written submission. I'm at paragraph 3. Those issues were not raised in the pleadings. What does the petitioner raise in his pleadings? I'm at paragraph 4. He raises what I call first world complaints. Voters were not tallied properly. There was technological failure. Transmission was late. Voters were not counted. It's like, the Florida contest between Bush and Al Gore. But my Lord, what comes out very clear is that this is a case that is not based on factual incidents on the ground. This is what I call a boardroom petition. People said, if we were doing a scientific case, it's a laboratory test, really. If you look at the issues they are complaining about, it is issues that the party look at the statute and say that, Section 3 has not been complied, Section 4. The factual incidents that underpin this petition is amazingly absent. But my Lord, my learned friends have told you to keep many things at the back of your mind, if there is space, which I am sure there is. Which I'm sure there is. My Lord, I would like to pose one simple question. One simple question. Having looked at the 12 million votes that were cast, why or how did the petitioner come only with a disputed figure of about 8,000? That is the 8,000 or the threshold that will trigger a runoff. That's why I'm saying this is a boardroom petition. If they had a good case, why wouldn't they have brought evidence to show that the disputed vote, for example, is 200,000 or 300,000 or 400,000? Why don't they even reach the a threshold of 10,000? They have found only the threshold that if you deduct 8,000 from the third respondent, you will trigger a runoff. My Lord, the second respondent and the first respondents are opposing this application. I state that in paragraph 2. We are relying on the documents that we enumerate in paragraph 6. And my Lord, paragraph 7, we are saying that having listened to the all parties really, there's no cause of action really. I mean, the petitioner does not plead a bona fide cause of action. If there was a procedure, we will have struck it long time in limine. My Lord, if you look at paragraph 9 to 16, I said that for us to understand the grievances of the petitioner, we have to deconstruct his political persona, my Lord. Because what we are being subjected to here is not a constitutional threshold of whether the election was free or fair. No, that's not the threshold. The threshold we are being subjected to is what I call the petitioner or the Raila's doctrine of free and fair election. That is the doctrine we are being shown to disapprove. And what does that doctrine mean? It shows that for this country to have a free and fair election, the petitioner must win that election. Anything less of that, then there is no free and fair election. My Lord, I take you through page 11, paragraph 11, paragraph 12, paragraph 13. We go through the history of the petitioner's participation in presidential elections and the scenarios that have unfolded in all those situations, my Lord. And look at, again, my Lord, look at paragraph 14, paragraph 15, paragraph 16. Paragraph 16, my Lord, is when we had the presidential debates, the petitioner gave the best sound bite, or the TV sound bite, when he said that the third and fourth respondents cannot rule Kenya through Skype if they go to The Hague. But my Lord, I think, my Lord, as someone who knows one or two things about computers, he has a screensaver to say that no matter what happens, in every election, his votes are stolen, whether it is 1997, whether it's 2007, or whether it's 2013. The only thing that changes is the year. My Lord, I draw your attention to paragraph 17. I have to emphasize paragraph 18, my Lord. Paragraph 18, the petitioner at paragraph 2.1 of the petition says the following. He says, and I quote, the petitioner seeks to effectively set aside not simply the result as announced by the first and second respondent on 9th March 2012, but the whole of the electoral process leading thereto, my Lord. My Lord, this is an enormous issue that he has raised in paragraph 2.1. The petitioner is not interested about the result alone. He does not want you to set aside the result alone. He wants you to set aside the entire electoral process leading thereto. And I think my learned friend Mohammed, when he was talking about the consequences of your order, was alluding to this. In other words, my Lord, he wants you to throw the register out of the window, because with the current register, he can't win an election. He wants you to nullify all elections, from governor, from members of parliament, from all this. But most importantly, he wants you that if you make an order for rerun, that there will be no way to run an election, because he will not accept all those things. He will not accept the first and second respondents. So, my Lord, if we accept the prayers of the petitioner, there will be enormous constitutional crisis facing this country. Those are his words. Those are not my words. Those are his pleadings, that he wants to set aside the entire electoral process. And I think the consequence of that is that the coalition government will continue ad infinitum. My Lord, I will go to paragraph 19. Paragraph 19 basically summarizes the grievances, the pleadings of the petitioner. Paragraph 20 and 21, my Lord, sets the legal basis of that. And my Lord, in reply, we reply to those issues at paragraph 22. I think there are about 6 or 7 issues. But my Lord, the first issue I would like to address is at paragraph 23, the powers of the Supreme Court under Article 140. Nobody doubts, my Lord, that you have powers to set aside the election and call for a fresh election, but those are powers you can only exercise if you look at paragraph 28 and 27 and 29, 30, my Lord, and 31. You can only exercise that powers under Article 136, 137, and 138, my Lord. So, my Lord, the issue of procurement, even though we know that the principal actor is the petitioner, is still not an issue for this court. You can only address the issues in 138, 137, if relevant. This is what the court said. Courts are ill-suited to adjudicate upon issues where court orders will have multiple social and political consequences for the community. Of course, they were addressing socio-economic rights. The Constitution contemplates rather a restrained and focused role for the court. And I have emphasized that, that emphasis is mine, a restrained and focused role for the court, namely to require the state to take measures to meet its constitutional obligation and to subject the reasonableness of those measures to evaluation. Such a determination of reasonableness may in fact have budgetary implication, but not in themselves directed at rearranging budgets. In this way, the judicial, legislative, and executive functions achieve appropriate constitutional balance. So, my Lord, it's my humble submission. It appears at page 538 of my authorities. I think in a dicey political question like this court must adopt a restrained and focused role so that it does not jump into this dispute. And even when it jumps, because I will later on show you, I will later on share with this court what a professor called the philosophy of passive virtue of a Supreme Court. Passive virtue. But before we reach that, my Lord, I think a restrained focus, a minimalist role. I support a maximalist role, my Lord, when you're adjudicating human rights or constitutional issues between the state. But in a political case like this, I think it will be good for both the country and the court to adopt a restrained, cautious approach. My Lord, I will invite you to look at paragraph 47 of my submission. At paragraph 49, my Lord, I have shared with you the theory developed by Yale Law School constitutional theorist Alexander Peckel, when he has argued in many books and articles on what he called passive virtues. He says for the Supreme Court to crystallize and to have authority in a country, it must exercise very passive virtues. It must not jump and decide cases in a very expansive manner, my Lord. And my Lord, you will find that at page 495, footnote 83, is that where I quote, where he says, there is a natural quantitative limit to the number of major principal intervention the court can permit itself. A court unmindful of this limit will find that more and more of its pronouncements are unfulfilled promises, which will ultimately discredit and denude the function of a constitutional adjudication, my Lord. My Lord, I will turn to page 50. And now, at paragraph 50 and 51, my Lord, even, and this one, my Lord, I'm not addressing the Chief Justice in particular, but in America, they have the tradition that the tenure of the Chief Justice defines the court. You know, the Rehnquist court. Now we have the Roberts court. And there's one decision which I could not get the full citation, but it's available. And unfortunately, I did not give you the citation of this book because I have it, but I couldn't get it today. I wanted to photocopy it. But this is the famous Obama health care. and the learned author in his book, which was published last year, is addressing why Justice Robert, as expected, did not side with the 4 consecutive judges, and he sided instead with the 4 liberal judges and upheld the Obamacare. It was not his reading of law alone. Look at what the learned author, my lord, says at page 52. He said, Robert's vote in the healthcare case will trump even Citizens United as a symbol of his tenure. Citizens United defined the public image of the Robert case in the way George versus Al Gore, another decision stepped in partisan politics, symbolized the Rehnquist Court. In terms of public perception, the healthcare case presented the 3rd installment of this legal trilogy, the next occasion when the court will wade into the political thicket. Unlike Bush versus Gore and Citizens United, the newer case did not deal directly with the business of election, but instead presented something almost as inflammatory, the Republic-dominated court verdict on the central achievement of a democratic president. He goes on down and says, Robert had a dual role for his tenure as Chief Justice, to push his own ideological agenda, but also to preserve the court's place as a respected final arbiter of the nation's dispute. And my lord, that is the reason why Roberts decided to uphold the Obamacare health. He thought that in a year of election, if he sided with the 4 judges on the right, everybody will make a political gain. So he said, do I purify my political ideology, or do I cast my lot with building respect for the Supreme Court? And that's what he did, my lord. It continues, he says, Scalia's version of the justice as gladiators against the president unnerved Roberts. As Chief Justice, Roberts felt obligated to protect the institutional interest of the court, not just his philosophical agenda. So, my lord, it's very important that the Mutunga Court, because this is now the Mutunga Court, lay the most sound and solid basis for this court. And my lord, I have no doubt it will. My lord, at paragraph 45, I stopped that issue of restraint and focus, what I call it. My lord, the next issue I would like to go very quickly is issue of technology, because technology has been made like it cannot fail. It fails everywhere in the world. It failed in America, it fails in Russia, it failed everywhere. It failed in the Philippines. Look at paragraph 55, my lord. Paragraph 55, my lord, paragraph 56 and 57. 58, my lord, is a decision of the Supreme Court of Philippines, which appears at page 172 of my list of authorities. In this case, before the election could be held, a party went to court and said that the Electoral Commission of the Philippines wants to go or wants to implement technology for the next election. And my lord, they advanced the same complaint as the petitioner advanced. They said the machines could fail, they could be manipulated. And look at what the Supreme Court of the Philippines says at paragraph 58. It says, the disruption of the election process due to machine breakdown or malfunction may be limited to a precinct only or could affect an entire municipality or city. The worst case scenario, of course, what we have faced, will be a wholesale breakdown of the 82,000 PCOS machine. Nonetheless, even in this most extreme case, failure of all machines will not necessarily translate into the failure of elections. Manual count tabulation and transmission, as earlier stated, can do. PCOS being a paper ballot machine, if the machine fails for whatever reason, the paper ballot will still be there for the hand counting of the votes, manual tabulation and transmission of the ERS. My lord, I mean, this is what happens everywhere in the world. My learned friend and his client, the petitioner, wants this court to believe that if the machines fail, you close shop. You close shop. You close shop. You don't continue with the election. It doesn't make sense. There must be a procedure that kicks in immediately, or immediately the electronic system fails. I mean, this country is bigger than the coalition government. We can't. My Lord, I think, my Lord, what the Supreme Court of the Philippines said is the right thing to do. Try the machines. If it fails, there is the manual. And the important thing is my learned friend did not explain what prejudice they have suffered when the manual system kicked in. What was the prejudice? Of course, the voters waited long in the line. That's for us to complain. Of course, the result took 4 or 5 days. That was for us to complain. What is the specific complaint the petitioner has that the electronic system failed? None whatsoever. There is no prejudice whatsoever. My Lord, that decision again was vindicated in another case at paragraph 60, my Lord. If you look at paragraph 60, I have given you another decision of the Supreme Court of the Philippines. It appears at page 176 to 181 of the list of authorities, where the court said that the world or the electoral system of a country is larger than machines working on a given day. My Lord, this I will not take a lot of time. I will be very brief with issue number 3 and 4, what I call what are the thresholds to invalidate an election. And my Lord, I'm sure you will read paragraph 63. The burden of proof does not shift. Who he alleges must prove. I think that's section 90 or 91 of the Evidence Act. My Lord, paragraph 64. It's not even beyond a reasonable doubt, my Lord. It's 100% test because of what is at stake. My Lord, if you look at 64, 64 analyzes section 83, and my learned friend, I think, gave us an authority from the Court of Appeal, James Ominga Magara and others, my Lord, which analyzed the equivalent, my Lord. But my Lord, although this decision was a split 2-1, I just want you to look at the majority decision written by Justice Omolo. Look at my Lord, page 1. This is what the learned judge says. In my view, the really serious issues raised by this appeal is the scope of section 28, the equivalent of section 83 of the laws of Kenya. This section provides, he cites that case. That's the last time you hear of him. He has not analyzed what the section says completely. Nowhere does he talk about it. The next time he revisits section 83, section 23 is, my Lord, at page 9. This is what he says. In my view, these irregularities could not have been cured under section 28 of the National Assemblies. That section cannot be used to cover a situation where even the source of the vote in the ballot cannot be conclusively determined. Where is the analysis of what section 28 is? Where is not? So, my Lord, it's not an authority really of what section 28 says. And my Lord, to be fair, I think that analysis is found in the dissent judgment of Justice Gidinji. That he analyzes what section 28 means. What are the evidential thresholds you meet before you invalidate elections, my Lord? And I invite you very briefly to look at page 13. He analyzes section 28 in depth and says that X, Y, Z must happen. He says, I will give a similar construction to section 28 of the Act. In a nutshell, section 28 of the Act means that irregularities in the conduct of an election will not vitiate the result unless the irregularities either were so serious that the election was not in accordance with the principles laid down in the law, or the irregularities affected the result. So, my Lord, it is the dissent really that analyzes the law, not the majority decision written by Justice Omolo, my Lord. But, my Lord, look at paragraph 65 of my submission. I have given you a lot of authorities. I will not read it. Paragraph 66. The tests that are established in Morgan and others versus Simpson and others. And my Lord, 67, the case of Ibrahim versus Shehu Shagari. And my Lord, at paragraph 68, you will find the substantial test established in the Besije case, my Lord. That's my last authority. Comparative analysis, my Lord, if you look at paragraph 69, paragraph 70, paragraph 71, 72, 73, 74, 75, Indian cases, and it goes on and on and on. And my Lord, the test which I'm inviting this court, the test, my Lord, which I'm inviting this court is at paragraph 78. This is what I call the 100% certainty that the election was sham and travesty. That is the test you have to adopt. If you are to nullify the presidential election, that is the test I invite this honorable court, my Lord, to consider. I use certain 100% that you should overturn the votes cast by 12 million Kenyans and find that the election was sham and travesty, my Lord. That's the question you should answer. If you say yes, you can overturn it. But if you are 99% sure, there is 1% doubt, you should not overturn it. You must show restraint for the will of the people. And my Lord,
Nasir,
yes.
Are you proposing a setting of a standard, another standard beyond a reasonable doubt?
Yes, yes, my Lord. I'm proposing because the issue of presidential election has been litigated all over the world, and I could not find one country where the Supreme Court has nullified a presidential election.
Such a standard would be beyond the criminal standard.
Yes, yes, it's, yes. My Lord, criminal is a trivial issue to try a criminal case. Of course, it concerns liberty and a lot of things. But when you consider a presidential election, which attracted 86% voter turnout in a country, and you are considering whether you should set aside or not, the test I think that can befit the magnitude and gravity of that decision is 100% test certainty. It will be a travesty of justice if we will overturn such a decision because a polling station opened late, or one extra person voted, extra people vote. Even in England last time they voted. A 16-year-old boy voted, my Lord. Because they want to test the system out of habit. It happens everywhere. In America, my Lord, felonies, people who are jailed, who are not supposed to vote, vote. So, my Lord, the issue you are facing is huge, not in terms of law, but can you invalidate the will of the people? For example, if you are 70% certain, no. It's too grave a decision that you can invalidate the will. And that is why not one country in this world, and my Lord, I'm sure you look at the Besigye case. The Besigye case, the Supreme Court of Uganda was divided 3-2. And they were all united 5-0 that the election was imperfect. And it was not like this one. There was a lot of violence. There was a lot of intimidation. There was a lot of voter bribery. There were a lot of people who were refused to vote. Issues that are not present here. That's why I said at the start of my submission that this is really a technical petition, a statutory and regulation based. It is, the basis of this is just statutes, you know. Rule 12 was not complied with, Rule 13 was not complied with, Rule this was not complied. But if you look at the Besigye case, the Ugandan case, I mean, there were gross violation, my Lord. Many people could not vote. There was a lot of violence unleashed, but the court, 5-1, agreed that all those things happened. But whether they could overturn the will of the people, it was a 3-2 decision, my Lord. Oh, but this one is so different, my Lord. The petitioners combed up through everything. They came with a difference of 8,000, and that, my learned friend Nani and the Nyamodi showed that even that's not true. That I think is the example Nani gave, that case in Pokot. I mean, it's a most classic case. The one person who was not on the register was allowed to vote because he was in the group. I mean, it was such a perfect election, my Lord. My Lord, if you turn to the last page now, if you turn to page 80, if you turn to paragraph 83. First, my Lord, my learned friend makes the point of, you know, that the margin was so small. He said it was only the threshold was only 0.7. My Lord, just to turn his argument upside down, the communist example he gave, if there was rigging in this election, if IEBC and the chairman have colluded with the third and fourth respondent, for this process to have been academic, they will have raised it to 75, 80. or 90%, if it was within their power. That it was that small shows how perfect this system was, my lord. The second and first respondent left the parties to their own. But if my learned friend's thesis is true, which is not, why didn't they give him a 75% or 85% result? So that he will say, but the difference between us is 3 million really. It's so big. But my lord, it is that small. It's that small shows that the parties were left to their own. And the election was credible. It was not sham. I agree with him, my lord. Hosni Mubarak, when he used to run in Egypt, he used to get 97%, 98%. Yes. But that this case, the difference above the threshold is 7%, shows the integrity of the process. My lord, look at paragraph 80. We said 86% turnout. Long queues, patient and peaceful voters, 12 million. 7 or 8 hours to vote. Elect your preferred candidate. No violence. No polling station demolished or invaded. No ballot box. I mean, there are some countries, you know, goons run away with ballot boxes. Not one ballot box was disappeared. My lord, can you say that that election was travesty or sham? Objectively, my lord? My lord, let us be fair. This election redeemed the image of this country. The template used by my learned friend and the petitioner has been thrown to the dustbin. The template of 2007. That is caremongering tactics. That it almost became 2007. That is now history. I think the 2013 election redeemed our image. We did a peaceful election. Kenyans voted. The election was to the threshold established by the Constitution. My lord, as I said, we cannot equate free and fair election to the desires or the historic desires of one person, my lord. My lord, it's my humble submission that unless you have any question, before I finish, my lord, I'm sorry. One issue about my learned friend's Ms. Kilonzo's evidence yesterday. I wish it was here, but my lord, that video, I don't know where it was recorded, probably River Road. Yes, she cannot disprove that that video was stage managed or recorded in River Road. I don't know what it was. I was the closest person sitting to it, and I watched it from the laptop. And I mean, I think it was of no property value. And with tremendous respect to her, the less I say about it, the better. My lord, unless you have any question.
Yes, before you have urged the court to adopt this approach of judicial restraint in matters of this nature. And you have cited the examples of American Supreme Court and other Supreme Courts. It has set me worrying because you didn't seem to contextualize that theory and bring it back to the Kenyan situation in terms of the history of this country, where there was no room for people to express themselves, even the way you are in this court. And we now have a new constitution, fairly expansive. We all agree with the edicts on how I don't want to engage us by responding, but before you sit, just I wanted to remind you of the worry. You talked of the Mutunga court. This is the Mutunga court. And the court has just been in existence for 2 years. If this court were to adopt that approach in trying to resolve serious issues like these ones, as you agree, then there will be, of course, the Tunoi court and the Ojuang court, because the Constitution has just begun to flower.
Yes, my lord.
I just wonder, by the time the Wanjala Supreme Court comes, What shall we decide? Because we shall have restrained ourselves into irrelevance. But I don't want you to respond.
My Lord,
I just wanted you to, as you retire also, because we have been urged to think about these things as we retire.
Lord,
but think about that
Yes,
one.
my Lord, I have 14 minutes. Let me spare one more minute. I'm not saying, I'm in support of a maximalist approach of a court like this when you are deciding issues of human rights and things that are beneficial to the wider society. For example, when you are deciding the two-thirds majority, I mean, that was a decision that was of fundamental consequence to this country. If you have decided like this or like this, and I think the dissent by the Chief Justice was counter-majoritarian. I mean, just like the South African court, decided the TAC and the two cases I've given you. He wanted to, navigate the country like this, but the majority could not see with him where he was going. But my Lord, in terms of a political issue like this one, that has really no important legal issue in contest, and it's just a contest between two crown princes of Kenyan politics. I mean, what is it in this court if it adapts and rushes into it? It's nothing. It is of no precedent value tomorrow, because you are settling a very narrow dispute between the third respondent and the petitioner, whether they should go for a run or for a run. So, in a dicey political question like this, I'm advocating for restraint. But when you come to, for example, whether, like, for example, if this issue of this special register that contains, disabled people who don't have biometrics, whether they can vote or not, I mean, that is, a decision that can expound the frontiers of liberty, my Lord. That one, you must adopt an expansive, even an intrusive interpretation. But this one, I think it is good, especially for a young court like this, which is crawling, I think, if I may put it, in terms of, age. I think it is good for it to show judicial restraint. You will find opportunities later in life where you can express yourself more.
So in other words, you are saying there is no danger to the Wanjala court.
No. Okay. I may sit in that court, my Lord. My Lord, am I released? I must oblige, my Lord, and I treasure this moment.
Good afternoon, my lords. The beauty of coming after Mr. Ahmed Nasir is that the court is fully awake, and so I can be able to address your lordships. Now, my lord, a lot has been said in connection with how the elections were held, and I don't want to go back to things that have already been dealt with. I will just cover a few areas which I think it is important to either amplify or address because they were not either addressed or sufficiently addressed. My lord, the first issue that I need to deal with is the question that was raised by my learned friend. This is by way of answer, Ms. Kilonzo, where she said that the allegation that the elections results were altered was not challenged. I think, my lord, from the submission that have been made by Mr. Mungai today and by my learned friend, Mr. Nyamodi, are sufficient to show that that issue has been challenged and traversed. And I do not need to say more about that issue. The second issue, my lord, regards the question of the registration of voters. Now, my lord, you'll notice that my learned friend, Mr. Oraro, when submitting, read to you the provisions of Section 4 and 5 of the Elections Act. What he didn't read for you is the provisions of Section 10 of the Elections Act. And my lord, Section 10 of the Election Act says, a person whose name is entered in a register of voters in a particular polling station and who produces an identification document shall be eligible to vote in that polling station. Only two requirements. You must be registered in a register. Your name must appear in a register. Unlike Section 4 and 5, this doesn't make reference to the principal register. Remember, my lord, if you look at the provisions of Section 4, there is the article, the principal register. This Section 10 says that if your name appears in a register, and you produce the identification document that you used to register, you are entitled to vote. And that is why, my lord, you'll find that there is, when the reference was made to the reference book, anybody whose name appeared in the reference book, or as otherwise referred to as the green book, and produced the identification document he used to register, was allowed to vote, because that's a requirement of Section 10 of the Elections Act. Now, my lord, the other issue that I also wish to make reference to is the provisions of Article 82 of the Constitution of Kenya. Now, my lord, you are referred to people who don't have certain features like fingers, or they don't have the hand, or their biometrics cannot be taken. Now, my lord, you'll notice that the Constitution had the legislature to come up with the legislation that makes provisions for, among others, and I read it for you, my lord. Parliament shall enact legislation to provide for legislation required by Clause 1D shall ensure that voting at every election is simple, transparent, and takes into account the special need of persons with disabilities. So by virtue of allowing people who don't have certain features, by virtue of either birth or for any other reason because of the nature of their work, the fact that there was special attention that was paid to those people by the requirement that they will vote even if they're not in the biometric register is in compliance with the provisions of Article 82 of the Constitution. I'm allowed to show just how much IBC went to great extents to comply with the requirements of the Constitution in terms of what the Constitution intended. Because when the Constitution says legislation shall be enacted to provide for, that's what the Constitution requires should be done. The second thing it says that it shall also take into account other persons or groups with special needs. And my lord will notice that when the queue grew longer and longer, people who were carrying children, for example, were allowed to vote. Old people were allowed to vote instead of queuing the whole day. Were allowed to vote without queuing. And my lord, the point that we are making is that the system adopted by the IEBC and the laws the Elections Act as provided met the threshold of the requirements of Article 82. My lord, the other issue is, and I'll just refer to this quickly as I move on. My lord, you remember that the registration period for purposes of the 4th of March 2013 election was completed on 18th of December. Between the 18th of December and the 4th of March, there was roughly about 70 or so days. Now, one of the things you are told is that nobody should have been allowed to alter the area in which you'll vote. That is where he was registered, because you're only allowed to do it before a period of 90 days lapses. Now, already for purposes of these elections, there was no period of 90 days in the first place. And so, my lord, to require you to hold that because there were changes that were effected outside the 90-day period, there was something untoward, is wrong, because the 90-day period in the first place was not there. Now, my lord, the other issue, my lord, that I need to comment about is regarding the provisions of Article, let me just get it, my lord, just now. As a background to that argument that I wish to advance, my lord, I wish to say this. My lord, one of the things that you were not told in the Constitution was the fact that the particular electoral areas referred to by my learned friend, Mr. Oraro, was a sampling done not by the IEBC, but was a sampling done by the petitioner himself. So both petitioners, that is AFRICOG and the Honorable Raila Odinga, came up with a sampling of specific areas and said, these allegations we are making in connection with Meru, in connection with the Rift Valley, and in connection with Kiambu show that there were people who voted over and above the numbers appearing in the biometric register. That was a sampling picked by the petitioners. Now, my lord, what the petitioners then turned around and say is because you provided answers in respect of the areas we picked, the evidence that emerges is your malpractices in those specific areas. And my lord, the effect of that is to balkanize the country, and it's wrong. And the reason why I alluded to this is this, my lord. while the petitioner has a constitutional right to file a constitution challenging the results of an election, he does not have a right to tramp on the rights of others to make electoral choices in accordance with the provisions of Article 38. He does not have that right. And my lord, the Constitution is very clear that you are only entitled to exercise your constitutional rights as long as you do not tramp on those of others. And so, my lord, the attempt to balkanize the country amounts to denying the people who voted in those areas a dignity that they are entitled to pursuant to the Constitution. They queued up like any other person in Kenya. They voted. They are entitled to respect of the choices that they make. They cannot be vilified, my lord, by virtue of the choices they made in accordance with the provisions of Article 48. It is wrong to balkanize the country. My lord, one of the most curious aspects of this petition that have been filed, there is not a single suggestion that has been made that there is a person who was not registered that was allowed to vote. There is not even a single suggestion. So while all manner of allegations have been made, not one person has sworn an affidavit to say, I was allowed to vote, although I was not registered, because then there would be a problem. Because a person whose name does not appear in any register is not entitled to vote. But no such suggestion has been made. Instead, my lords, what you are told is selective picking of names and areas and refusal to utilize the register that was available during the voting. And then you are told because there are some names that are missing from the biometric register, it means that there were some additional people who voted. And when an explanation is given, it is attributed to specific areas that were sampled by the two respondents, by the two petitioners. So, my lord, there is not a single issue that has been raised to show that there was impropriety in the admission of people to vote. When you consider the provisions of Section 10 of the Elections Act, and also when you consider the allegations made by the petitioners. Now, my lord, there is an allegation that has been made of collusion between the petitioner and, the third and fourth respondents and the first and second respondents. The interesting aspect of this matter, and it goes to show the independence of IEBC, is that yesterday, when we started the first petition, the accusation was that there was collusion between IEBC and the petitioner in connection with the issue of the treatment of the rejected votes. So, my lord, this is an institution where the two candidates who vied for, the two leading candidates that vied for the top seat, both of them are saying, in their view, they think the other guy was treated better. So, my lord, that only goes to show that IEBC carried its functions effectively, fairly, and in an unbiased manner, because nobody seems now to be happy with the result. So there cannot have been collusion between the IEBC and the two candidates. Now, my lord, there was a reference, my lord, that was made to the Political Parties Liaison Committee, and it only say, my lord, that if you look at the provisions of Section 38 of the Political Parties Act, it is provided for, and my lord, so it is a creature of statute, and it even explains that its purpose is to encourage contact between the Registrar of Political Parties, my client, and the political parties. And obviously, my lord, the political parties are the vehicle through which people normally express their political will. So, my lord, there was, this is a creature of the Constitution itself. My lord, as I sit down, let me also touch on the question of Article of Regulation 82, which was you are referred to extensively. My lord, you'll notice that the provisions of Regulation 82 contradict Section 44 of the Election Act. My lord, it's trite law that where there is a conflict between a subsidiary legislation and the parent statute, then the parent statute must prevail. Because if Parliament intended that the use of technology would be made mandatory, what they should have done is to amend the provisions of Section 44, which was not done. And so, my lord, for those reasons, you'll see, my lord, that really, in the petitions that have been filed before you, what has been done is that there are a lot of platitudes that have been given, but there is nothing that has been shown to show any wrongdoing on the part of the first and second respondents. And for those reasons, my lords, we urge you to dismiss the petitions and the prayers sought therein. Unless my lords have any questions, I wish to rest at that point.
Thank you. Lots of light.
My Lord, if I asked you to be restrained more, you might not hear the other two parties. So, thank you.
We'll break now and resume at 4:30. Mr. Gatia?
With your permission, my Lord, I hope the clock is not going.
No.
I recognize that the Honorable the Attorney General is now before you. When we resume, it was to be the third and fourth respondents. But if it is convenient to you, my Lords, and recognizing he must have numerous duties of state, I do not mind when we come back, he goes first, and then immediately we start our submissions. But this really is not an application, but a request to you, recognizing that he must have numerous duties of state.
But we wanted Mr. AG to have the last word.
Mr. Ngatia?
Yes, my Lord.
I thought the AG was the friend of the court. But it appears now you are his friend.
I worked in that office. I know there are numerous duties there. But in that event, then I'll go first. It will be 3 hours, 15 minutes. In the event, then he wants to wait here or to come back later. The choice is his.
Mr. Attorney General.
Chief Justice, with your permission, I'll be addressing you on only 3 points of law, and will take 20 minutes.
Okay.
I would be obliged if you granted me the courtesy to go first.
Okay, we start at 4:30.
Most obliged, my lord.
Okay, thank you.
You know your right hand is fine. I know you're likely to find your name in the list of senior counsel on this account.
Wewe ni Bwana juu ya mabwana, ufalme wako wadumu milele.
Hi, my name is Enid Mora. Easter is